My name is Edgar Rosales, and today I will be talking about PPMs, PPO, term sheets, and due diligence. First off, what is a PPM? A PPM is a private placement memorandum, which is a legal document offered to investors when selling stocks or other securities in a business. A PPM is used when it is a private transaction where the securities are not registered under associated federal or state laws, but are sold using one of the exceptions from registration. The PPM includes a company selling the securities, the terms associated with offering, and the risk of the investment, to name a few. The exemptions used from the registration, the complexity of the terms of the offer, and the target investors affect the disclosures included in the PPM. A PPM is ultimately a disclosure document that is descriptive, informative, and factual, but not persuasive, and allows investors to decide on the merits of the investment. So what is a PPM? Most PPMs are drafted in a similar format, which begin with an introduction that includes the basic terms of the offering and a short statement of the company and its core businesses, and a summary of the offering terms, which is usually in the form of a term sheet. The next section is the risk factors that are possible by the issuer and that may influence the investor's investment. This includes general risks common to similar investments and risks that are unique to the issuer and its securities. Following is a description of the company and the management, including the company's history, its industry, competition, and goals. Next, the company describes how it will use the net proceeds raised from the offering and the estimated amount intended to be used for specific purposes. Then there is a description of the securities that includes rights, restrictions, and the class of securities that are being offered. Next is, what is a PPO? A private placement offering is a capital raising event involving the sale of securities to a relatively small number of wealthy investors, with the offering not having to be registered with the SEC and have minimal regulatory requirements and standards. A private placement is far less expensive and faster, meaning of raising capital compared to an IPO, and investors in private placement offerings can expect higher returns for taking on greater risks. So next I will talk about term sheets. A term sheet is a non-binding contract laying out the basic terms and conditions under which an investment will be made. It is used as a template to develop more comprehensive legally binding documents, and once the parties involved come to an agreement on the details laid out in the term sheet, a binding contract can be written up. Term sheets are mainly used by startups as it is crucial to entrepreneurs for attracting investors, including venture capitalists. Information included in term sheets include the valuation of the company, the amount to be invested, the percentage stake sought out, voting rights, and liquidation preferences, among other things. So a term sheet should cover the most important aspects of a deal without going into every minor detail that can be covered in a binding contract. It lays out the groundwork for ensuring that all parties involved in a business transaction agree on the main aspects of the deal in order to decrease the possibility of a misunderstanding. It also ensures that any expensive legal changes involved in drawing up a binding contract are not experienced prematurely. All term sheets will contain basic elements including the parties involved, valuation, preferred payments, information about all the involved assets, initial purchasing price, and a time frame for a response, and any other significant information. Next, I will talk about due diligence, which is an investigation or audit of a potential investment to confirm all facts, which may include the review of financial records. It is also referred to the research done before entering into an agreement or a financial transaction with another party. Investors will perform due diligence before buying a security from a company, and a seller may investigate a buyer to see whether or not the buyer has sufficient resources to complete the purchase. Due diligence became a common term in the U.S. with the passage of the Securities Act of 1933, in which security brokers and dealers become more responsible for fully disclosing information related to the instruments they were selling. So what is it? The steps for investors undertaking due diligence begin with analyzing the capitalization or the total value of the company. This can provide an indication of the volatility of the stock price, how broad ownership can be, and the potential size of the company target markets. Next, an investor would analyze the company's income statements that shows its revenues and net income. They could calculate profit margins and compare them to other companies in the same industry. Investors will then do research on the company's management and see if it's still run by its founders or have new faces been brought in. Investors need to understand both the company's specific risk and industry-wide risks, including any outstanding legal or regulatory matters. Investors should also research both the short-term and long-term price movement of the stock and whether it has been volatile or steady.